right. Good morning, everyone. We will give everyone just a moment or two to get on board because I know that you have to click the disclaimer that says you understand that you are participating in a recorded conversation. I will also remind you, well, first of all, I don't know if this is good or bad, but you're stuck with me. And no Gary, no Adam. They're off doing stuff related to work and send their sincerest apologies. So I roped in one of my partners, Christian Staples, who we've done a lot of work with each other. I will tell you that there is an occasional eye roll from Christian because he's a litigator. And then when I get out of my lane and I write a demand letter, and in some occasions draft the first draft of a complaint, his first question usually is, okay, when you need my help, how far have you gotten? Meaning, how much have you screwed this up so far that I need to fix? So that's kind of the starting point of things that we do together. But based on the topics that we are going to talk about, I thought it would be very relevant to have one of my partners who's in litigation who sees the good and the bad on the litigation side of things if the things are done properly or improperly. So want to go through some of that and kind of just get to the heart of things, but also want to provide Christian an opportunity to give us the 30,000-foot resume of his just basically, and I didn't tell Christian he's going to do this. I just said, hey, come join us and hang out. And, we have a good time. It's very conversational, awesome audience. And so, Christian, if you want to give kind of like the elevator pitch resume of your background.
Okay, happy to. Thank you, Jack. Thanks for inviting me along for this. I've heard a lot about it and never participated, so I feel very honored to join this esteemed group today. As Jack said, I'm a partner here at Shumaker in the Charlotte office. I've been with Shumaker my entire legal professional career, about 16 years at this point. I'm what they call a business litigator. So I handle everything from breach of contract, business torts, unfair trade practices, employment disputes, construction disputes, really you name it. I've probably at least dabbled in it at some point along my journey here, but mostly stick to, what we would deem business disputes and how to resolve those through litigation, whether that's in court or in an alternative resolution forum like a mediation or an arbitration. And I do work a lot with Jack and other corporate lawyers because business litigation often feeds corporate work and vice versa. So we have a lot of mutual clients that we serve, and that's probably a good summary for me.
Excellent. So I appreciate that. It's funny, I need to tell Adam about this. Since I'm the host and have the power of the host, I noticed that there's a pause button there on the recording. So maybe in anticipation of Adam saying something that we may not want recorded or get to the FBI in the future, maybe we should start using that. So what I want to talk about, and as you've seen in the post, is just some general but also getting down a little deeper into it than we have before on certain topics. And so kind of getting to the beginning, and it's a question that we get a lot, which is, oh, and I'm sorry, I'm not as good a host as Gary. Reminder that we have the chat and we have the Q&A that you can certainly ask questions about anything, not just about what we're talking about. If there's something that's on your mind, I will remind you that this is conversational, general guidance. It's not legal advice because we can't do that because we don't know the specifics of your situation. And although some of you who ask those questions are current clients, we still would need to know more about what's going on outside of this discussion. So the first question that we typically get is, hey, I need to form a new entity. What should I choose? LLC, corporation, don't know about tax. And so I'm going to go back to a fundamental tenet of entity formation, which is the legal aspects and the accounting aspects are separate considerations that you can mix and match essentially, where in the past you could not. So you have not only a choice of entity, but you also have a choice of tax classification. And what I mean by that is you can at the outset choose to be a corporation or an LLC. And then choose to be taxed as how you would be taxed under default LLC, which is either a sole proprietorship for one person, a partnership for two or more people, or you can be taxed as a C corporation or an S corporation. What we typically see is the choice, and as those of you who were on 2 weeks ago had the experience of Warren Keene being on this program, and who us, I think, stated on there that he has not dealt with or formed a true corporation in about 2 decades. He always goes to form an LLC because there's more freedom of contract. The operating agreement is the gospel and the Bible for your business. And then you can choose if you need to be a C corporation, which would be appropriate, for example, for an entity that is coming into the US, a foreign entity, to have a blocking corporation, which we've talked about in the past, or an S corporation, which has its benefits for smaller businesses and other things that we've talked about that we could spend the whole time talking about today, but we're not going to do that. So just the point that you can mix and match. So the next, and I want to kind of talk about myths or things like that. So the next myth, besides you have to choose one path or another, is that by having an LLC or a corporation, that protects you in all circumstances from getting sued personally. And so then you hear the concept of what is called piercing the corporate veil. And Christian, if you might dabble into what that essentially means, which is basically a way that even though you have tried to separate your business persona and your personal persona, you have somehow destroyed that line between the two so that it is viewed as being commingled essentially.
Right. Yeah, I mean, it's sort of the fundamentals of, in a corporation, you have shareholders. In an LLC, you have members. Piercing that corporate veil just means you're looking behind the limited liability company or the corporation. You're looking behind that legal, uh, call it a fiction, I guess. I mean, it exists, but it's really just exists because you've registered it with your state secretary of state or whatever. But to hold the individuals behind that corporation or LLC personally liable for debts or obligations of the corporation or the LLC. And there's well-established case law, probably in every jurisdiction, as to how you go about doing that. And it's difficult to do, but it can be done, in certain circumstances. And Jack, I don't know if you want me to kind of break down sort of what those circumstances are, or um,
Yeah, so I'll share, I'll give you the list and then you can expand upon it because I did pull kind of the case that is cited to often in North Carolina, which is a 1985 case. And in that case, three elements: inadequate capitalization, failure to follow corporate formalities, and complete domination and control by the owner. So if you want to maybe dabble into those topics.
yeah. I mean, they're pretty self-explanatory, right? It's like you need to have separate bank accounts. Don't use your personal bank account as the account for your business. Make sure your business is adequately capitalized. It has appropriate levels of insurance. Keep books and records. One of the most important things is make sure you're filing your annual reports. I can't tell you how many times I see entities in litigation, whether it's plaintiff or defendant. I always check the Secretary of State records because it gives you a lot of information about, who the owner is, where their principal place of business is. And a lot of times you'll see administratively dissolved, didn't file annual report or didn't pay annual fee. And so that, there's more to corporate formalities than that, but that's at a most basic level something you should do. Document annual meetings, right? If you have votes, right? If you have a multi-member LLC that requires votes for certain things, make sure you have some kind of documentation of that. Otherwise, it just becomes he said, she said, and if you're in a dispute, memories will get, mixed. So, what do
Yeah,
you think,
and
Jack? Is
so
that you want to
yeah,
cover
and
some
so
more
I'll
of
give
that?
you absolutely. So Yeah, I mean, the my cheat sheet notes, inadequate capitalization, so you don't put enough money or have insurance in the company's name to cover those kind of things, commingling, no proper records, using business accounts, facade, alter ego. So a couple of examples if would be, um, and I get it. So at the end of the day, meaning when you're paying your taxes the subsequent year and you have money left over in the bank, and by the way, you're going to get taxed on it if you're a partnership and or you're an S corp or you're a C corp and there's been distributions, dividends paid to you as a shareholder, you're going to get taxed on this stuff. At the end of the day, that net income that's sitting in your corporate bank account is yours. But you really do need to distribute those funds and then pay your mortgage, pay for your boat, pay for your second home, all these other things, even though it's your money. Another example would be paying the rent for your business premises out of your personal account, to subsidize that. Maybe there you were waiting on some income or some revenue, and you're like, oh, I'm just going to pay it with my personal check and I'll pay myself back. That's really not a good thing to do, and is just indicative of you're commingling those kind of things. And then one thing that maybe isn't brought up as often, I mentioned a moment ago, is insurance. So that you are inadequately insured. And there are nuances associated with that. So, for example, let's say that you have a liability policy that is, for the business, sufficient coverage, but then you have an umbrella policy under your personal name, and you're using that to supplement your business insurance, which you're permitted to do as an owner in many cases for umbrella insurance, in addition to subsidizing or increasing your auto coverage and your home coverage. But you are utilizing that to be sufficiently covered for a particular project that you're doing where you need additional coverage. There is a possibility that that might be an indication of piercing the corporate veil. So just be mindful that, the things that you think are probably okay, you should maybe reconsider when you're thinking about that deep line that should be between your personal assets and your business liabilities. So think of it as kind of a grid with company assets and liabilities and personal assets and liabilities, and a diagonal between those that you're trying to protect one from the other. Um, piercing the corporate veil is a myth essentially that needs to be addressed. Let's talk about threats to your personal assets based on business liabilities, which is kind of a good segue from piercing the corporate veil. So there are a handful of things that Christian and I deal with routinely. Obviously, dealing with lawsuits and people getting sued back and forth, but you can create personal liability in other ways. Um, One is by personal guarantees. And we've talked about that. And I would say, and Christian, I don't know if you agree with this, but from my perspective, there are four incidents, four times primarily that you will enter into a personal guarantee. One is with your bank, two is with your landlord, three is with your franchisor if you're franchise, and four is our engagement letter that we are going to definitely have you sign personally, when you're signing up your business entity as being the client, because we want to be able to get paid. If we don't get paid by the company, we want you to pay our bills. So, but discuss maybe, Christian, some other things with respect to, whether it's divorce, business partner disputes, creditor claims that, business owners might do in order to protect themselves on the front end, either through the operating agreement or through other relationships.
One of the things that always comes up with personal guarantees is to think about, okay, am I married, right? Am I giving the personal guarantee? Is my spouse going to also be asked to co-sign? Because at least in North Carolina, and states can differ, but if you own your house as marital property, and one of the spouses signs a personal guarantee, that's not gonna subject the marital residence to liability for that. But, so those are conversations to have, and those are, maybe implicates an estate planning attorney to look at some of that as well if you're going to be co-signing or guaranteeing a large obligation. I see somebody has asked a question about where do trusts fit into that protection. I mean, trust would be a great idea, because if you're giving a personal guarantee and you have assets in a trust, that personal guarantee should not implicate the trust. There may be some exceptions depending on what kind of trust it is, but I'm not an estate lawyer, so I can't really speak to that exactly. But those are the issues that come up, and a lot of where we counsel clients around is, okay, you've been asked to give a personal guarantee, but rather than just fully guaranteeing, 10 years of a commercial lease, let's put some limits on that. Let's cap the personal liability exposure. And you do that by saying, look, I'll guarantee 1 or 2 years of the lease, just minimize things. And there's various ways to do that. That's where the lawyers come in. But I feel like in most business negotiations, there's almost always room for negotiation. The exception to that would probably be your bank lender. They're probably not going to be very flexible, but those other guarantees may be.
Yeah, and I want to go back to the trusts, and I am also not a wealth strategies lawyer, but we deal with plenty of those situations with respect to business owners and just generally speaking. So, and as Christian said, there's a difference between a revocable trust and an irrevocable trust. And so what you're doing is you're basically saying, well, even though it's my asset, you're putting it into this artificial thing with a force field around it, essentially. And I'm getting into sci-fi stuff, which Adam would appreciate. So putting into this thing where creditors can't get to it because you have relinquished with an irrevocable trust, you have relinquished control of that. So you cannot control the disposition of the asset itself, nor of the revenue or the interest or the increase in equity that it generates inherently in whatever vehicle it's invested in. And so that's why now revocable trusts are treated a little differently. And again, we could spend a lot of time, or one of our partners could spend a lot of time talking about that, and happy to discuss that further and put anyone in touch with the appropriate person to discuss that. But another kind of concept of the trust is that it's not in the public domain. So I'm sure many of you know, but maybe some of you don't know, that if a deceased person, the person who processes their estate either does it as an administrator because there's no will in place, or would do it as an executor if there is a will in place. But the better way of doing it is to have a very simple will that refers back to and puts everything into a trust. And then the trustee can administer the trust, do everything that needs to be done that would be done in the whole executor process in the court system, but then does everything and then reports back to the court, to the clerk of court, that everything has been done, everything has been blessed, they pay their taxes, they represent all of that, the assets have been distributed or proposed to be distributed according to the trust, but it's no one else's business exactly what is happening to those things. And so the confidentiality and the privacy aspects of doing a trust is one of the major benefits of going through that process, and is what we recommend routinely for our clients that are going through this process. And it could be a trust that's created for kids, for grandkids, for spouse. You can have each spouse having their own trust, and then not knowing who is going to predecease the other, have it, pour into the other. There's tax benefits for doing that. There's tax benefits. It may be avoiding taxes, it may be deferring taxes. So again, all that should be part of a much larger estate planning, wealth strategies discussion with a professional who does that. Okay. So next kind of topic that I want to talk about is essentially legal landmines that you may be inching towards, maybe possibly stepping on, but not with enough pressure to actually um, detonate the landmine. So um, there is the concept of what happens when you grow too far too fast. And you have to, I mean, we only have so much time that we can address business issues, family issues, and everything else. And so, um, a lot of times, the band-aid that we have for that as business owners is let's just hire people and let's just have people do certain things and cover certain things, and then we'll figure it out later. And the problem is that that later doesn't come, and you don't kind of clean things up until there's a problem. So part of that is not documenting things properly, for example, in the form of an employment agreement. And, I would like for Christian to share some more stories dealing with employment arrangements. We're not employment lawyers, but we deal enough very much in that space. But my point is that uh, there is, again, another misconception myth that you don't use employment agreements unless you want someone to be restricted with a non-compete, which is absolutely not true. North Carolina, like many states, is an at-will state. Having a piece of paper that says employment agreement does not change that. It is basically, you can still have an at-will, and we have many of those at-will employment arrangements that are documented in an employment agreement, and will have non-disclosure, confidentiality, non-solicitation, and then you get into the next level, which is the non-compete of a restrictive covenant. And so it isn't one or the other. There, and from my perspective, different levels of an employment agreement form, depending on the situation, depending on the person, depending on the job they're doing for you, and most importantly, depending on your legitimate business interests. That's the definition. What are you protecting? Are you protecting a legitimate business interest, or are you overreaching into and not preventing this person, or preventing this person from doing what they were trained to do, and you don't have a legitimate reason to not have them compete 100 miles down the road because it's not going to impact your business. So I threw a lot of stuff into there, but maybe if you want to, Christian, unpack that a little bit
Yeah.
into an employment agreement and that.
Well, a couple
Great.
things jumped out at me from what you said. One being the non-competes. I mean, there's been a lot of sort of chatter recently about whether or not, laws may basically do away with the ability to restrict somebody from competing. I don't think those have been implemented, but courts do look very carefully, and again, it becomes a function of what your state's law is. There's different legal rules that apply to non-competes and how you restrain, time, geographical areas. And so again, if it's really important to you, I would always say, run it by a good employment lawyer that can make sure that your agreement is going to hold up, because the consequence a lot of times is, even if, you know, most of it would be enforceable, if there's one thing in there that's not enforceable, the court may just throw out the whole clause. Um, Another issue that I see a lot with employment is people that will want to avoid an employment relationship. So they will draw up independent contractor agreements, and they will try to treat everybody as an independent contractor. But the courts would say it doesn't matter how you define the relationship, it's the law that defines the relationship. So, just because you have that independent contractor that both parties have signed, that is basically meaningless to a court. It might consider it, but it's going to ultimately look at the sort of factor test. To be an independent contractor, they basically retain the right of control. And if you're, they provide their own tools of the trade, so to speak. And if you're supplying all the tools and mechanisms to do the job, that person is going to more likely than not be deemed an employee, even though you've sort of classified them as an independent contractor. So that's another area. I was working with a client the other week where they wanted to do an independent contractor for like a 90-day trial period, before they hire somebody, and was successful to sort of talk them out of that, because it's like, look, employment's at will anyway. What are you afraid of, right? You're not married to this guy. If you hire him, you could still fire him for any reason or no reason. But the risk you run if you try to classify him as an independent contractor and under the circumstances, it was pretty clear that he was actually going to be deemed legally as an employee. You're just running the risk of, if it doesn't work out, you get sued for wage and hour claims or something like that. So that's definitely an area where you may want to seek legal counsel.
Yeah, and I got one for you. And this is probably a Derek question, but does the independent contractor rule apply when the contractor is not based in the US? I have my thoughts on that, but I'm curious for your thoughts and understand, again, this is guidance because I know for a fact the best answer that we give on this program ever is it depends. And it really does depend on a number of things. But what do you think, just generally speaking?
I'm not sure I would venture a guess at that. I have no idea.
Okay.
Again,
So
not a true employment lawyer.
yeah,
Um,
yeah, of course.
but
So
yeah, I mean, I guess if you're not based in the US and not a US citizen, I guess might go a step further, then maybe the laws wouldn't apply, but I don't know.
wow. See, that's why we get along so well. Your spidey sense is correct, I believe. So it is, again, my understanding that it would depend on whether it's a US citizen or not that is abroad. It would depend on, I think, the nature of the company that is it a US based company? Is it a subsidiary? And then also the type of work that's being done. So, is it products driven? Is it services driven? So, that those are going to be the it depends factors. It would also depend upon the foreign jurisdiction where the work is actually being done. And so, you see there are various reasons for work being done in places like India, economies of scale, but there's also favorable laws that allow employment related laws that are also a reason why and were purposefully put into place. Again, this is Jack theory, dad theory. I don't know this for sure, but I've heard this from others that in order to attract businesses to have labor done, mostly related to the electronic arena in doing things, contracts and those kind of things. But even things like word processing way back when and things like that before voice recognition. So again, the general answer is it depends on a number of circumstances, but so anyway, we'll roll with that. Um, Next landmine is the undocumented contracts or the term sheets or even the verbal arrangements or the verbal amendments to contracts. So obviously, best case scenario is you have a document that addresses all of the things related to the relationship, the who's paying for what, who's doing for what, who's responsible for when things go badly, and those kind of things. But, we don't live in a perfect world. So what we face many times is a document that either was contemplated and put into place, which is nothing more than a ladies and gentlemen's handshake. And sometimes that is exactly what it is. I mean, you hear the joke about, oh yeah, we made that contract on a napkin at a bar. We have seen that literally in our practices, not often, but the more generic way or what we see more often is an arrangement, a contract that was good for the moment, but then the relationship has evolved. It's evolved into doing more things, paying more money, taking more risks, and the contract does not evolve with the relationship. And so maybe if you want to talk a little bit about Christian about the things that you see that we have clients that come to say, well, that's the way we've been doing it. And so we assume, I mean, putting aside course of performance, course of dealing, but just generally, you may want to mention that as well. But the things that we have to deal with to say, well, it really should have been in writing, and this is why you're going to have a problem enforcing that provision because it isn't in writing.
Yeah. This is a little anecdote. My mind just goes to this, the topic that we're talking about. It pops up on my Facebook feed or maybe my Instagram feed or something, but I keep seeing it. It's that you've all probably heard of the sriracha sauce, right? And the company behind it, I think Hoy Fong or Hoy Farms, they apparently have a handshake deal with their pepper supplier. And I thought that was interesting. I don't know if it's true or not, but you see a lot of fake news sometimes on social media sites. But I just thought of that when you were talking about handshake deals and back of the napkin. But yeah, I mean, the problem you can get into is there's something in the law called the parole evidence rule, and it basically is that oral, verbal agreements can be inadmissible to vary a written agreement, and so there's nuances to it. There's exceptions to it, like pretty much everything in the law. But I think again, I mean, like Jack said, best practice is even if you have that verbal agreement, like just go back and document it. Say, hey, it was great having drinks with you, and I'm glad we reached an agreement. Can we just memorialize in writing the key terms, and let's both sign that just so we have a copy of it, so there's no dispute down the road about what the agreement was. Cocktail napkins, are easily lost and things like that. So, um, yeah, and to this fact that circumstances change, like as when you're starting out, you may not need the same level of care put into written agreements, but things over time can become more important. And as your business grows, it definitely becomes more important. We've litigated lots of cases where new business ventures maybe don't have an attorney to prepare an operating agreement, but then they open new locations and they expand and they take on, much more extensive obligations. And then they're still looking back to an operating agreement that was poorly written, that's unclear, that has a lot of holes in it. It's always good, I think, to revisit your operating agreements and contracts just to make sure they're still serving you in the best way.
And I want to mention kind of the generation or genesis of contracts in drafting them. And it's always a temptation to and I don't take this personally because it's available, to be your own lawyer and find the form on the internet to use moving forward.
Yeah.
The problem with that is that it may be suitable for the deal terms, as far as, okay, who's, as I said before, who's doing what, who's paying for it, who's responsible for shipping, who might be taking responsibility at what point. Is it when it's picked up from the warehouse? Is it when it's delivered to the receiver's warehouse or to the ultimate customer? So those kind of things. But what happens is that the back end, what people consider the boilerplate, is just kind of shoved in there because it's just, again, an assumption that that is suitable. So it may be in some cases that you would want a stronger indemnification arrangement in there because one party is taking on more of the risk than the other, and you want that acknowledged. And so that if there is a problem, then who is responsible for those things? And then you would want exceptions to indemnification. So a lot of times the boilerplate that we see is not sufficient. Um, I should say is sufficient generally speaking, but not sufficient for your particular deal, your particular facts and circumstances. Dispute resolution. In some cases, going to court and having a jury trial and having a judge and jury is better than having an arbitration provision. But we see it go in both directions, where it is an agreement should have an arbitration provision because you want, for example, to have someone who both sides can agree to, who is maybe an expert in the field, that understands the nuances of the industry, understands the technology, whatever it is, versus a generalist, which is what a judge is in most cases, and a jury who may or may not, if you're lucky, have a few people who have some general knowledge of the details of your business and the products and services that you're selling, so that they can input that into the jury deliberation process. So a lot of times what gets missed is also termination clauses. How do you get out of a contract? Sometimes they'll say, if you do well. I'll tell you what, why don't and I've said this before, but if you, Christian, would explain various ways to terminate a contract, meaning an evergreen provision with negative notice, meaning that you have to give 60 days, 6 months notice, or it just naturally terminates, and then there's an assumption it's a month by month thing, maybe particularly like in leases. So if you maybe go through
Yeah,
some of that.
sure. Well, I think, yeah, as you said, I mean, there's different ways that contracts can be terminated. I mean, one could be termination by expiration, right? Or non-renewal for some reason. You could have termination for breach, default and breach. One party elects to terminate. And, I would say, if you're going to do that, you better be darn sure that the other side is in material breach and that you're not also in breach or even a prior breach, because that's probably one of the most frequently litigated things when people terminate contracts due to another party's breach. The other party's just going to turn around and say, well, actually, we didn't pay because you didn't deliver, or things like that. There's also what in construction contracts they call it termination for convenience, where, or really I would just call that more of a voluntary termination right, where one or both parties reserve a right to terminate, maybe on a certain period of notice, or upon the fulfillment of some kind of condition, where it just says, I don't want to be in this contract anymore, or it's no longer profitable for me to be in this contract anymore. The assumptions that we had when we entered into the contract proved to be false, or the law changed and this contract's no longer legal or a good idea, or there can be any number of circumstances that over time would make a contract that when you entered into it be a great idea, and now it's either not working for you or there's something wrong with it. So yeah, I mean, I think the way we started is just make sure when you sign a contract that you know how you get out of it.
And I want to reiterate something you said, particularly in leases, and it's kind of maybe the number one sin and thing not to do when you're the tenant under a lease, which is to, I'm gonna pop quiz you, which is to, what should you not do if you're an upset tenant in
Yeah.
relation to the landlord?
So leases are unique. You cannot withhold rent even if you think the landlord is doing something wrong. Under the law, they will interpret a lease contract, the obligation to pay rent, is what they call an independent covenant. And so that covenant basically exists no matter what. You have to go to court and get an order. You have to get judicial approval to stop paying rent, unless the lease provides for it somehow. But most commercial leases do not. Most of them even will say, it's an independent covenant. And so, yeah, tenants, that's a real big pitfall. They say, hey, my landlord's not fixing the leaking roof, so I'm going to withhold rent. Next thing you know, you're being evicted and you're in small claims court trying to convince the magistrate that you didn't pay the rent because the roof leaks and the landlord won't fix it, and the magistrate's hands are going to be tied to help you there.
Yeah, and it's something that, and I know pisses people off, and we have these conversations. It is okay. So let me understand what you're telling me, Jack, as my lawyer, which is that I have a leaky roof, which has damaged a significant amount of my inventory. I have to have a discussion with my insurance carrier about this, and I have to pay rent, which they are likely using to create a war chest. They're giving the rent to their attorney to sue me for breach of the lease. And the answer is unfortunately yes, because that is the quickest way for a landlord to be able to kick you out of there and then deal with everything else down the road. So I just mentioned that because
Yeah.
we, again, one of the things,
Well,
yeah.
I think the moral is don't let those things fester, right? If you've given the landlord the appropriate notice, and again, look back at your lease and make sure you have given appropriate notice. A lot of times, that can be important that you follow the right procedures, but if they've not responded and addressed the issue, then I wouldn't delay, hiring counsel and try, taking that to the landlord's attention. I mean, that'll get their attention.
So speaking of things to have in a contract, what to include and what to avoid, I have a list. So I remind you that this is being recorded, so you can go back to the recording if you missed this, and I'll try to talk appropriately slowly and not rush through this. But just again, to kind of be efficient, I had a list, and to be very candid, I put it into Chat GPT to see if they could make it better. And they gave me some other things that weren't on my list, but I was pretty good on getting most of the things that it was spitting. It came back to me with. So smart clauses to include in every business contract. As we talked about payment terms, and do you use net 50/30 at a 1.5% monthly for late fees, for interest, those kind of things. Now, understand that usury law, and correct me if I'm wrong, Christian, but usury laws are really focused on consumer transactions and not necessarily business transactions. So you can't go off the rails and charge 50% interest, but you're not bound by usury laws, at least in the state of North Carolina. Is that still correct?
Uh, yeah, I think that's my understanding.
Okay. All right. So we talked about termination clauses and termination for convenience. So Christian was spot on with that. Scope of work regarding deliverables, milestones, and then if you are the one that is receiving the services as far as work goes, you want to make sure that there are caps on the amount of time within the budget and processes and procedures for going outside of the scope. Let's say that something happens that creates a delay, or that they discover something that needs to be fixed, or even a new regulation comes into place where they have to do something differently with respect to the safety aspects of the product being manufactured. So those kind of things should be addressed, and who is responsible for those things. Liability cap, we talked about that. A lot of times, I shouldn't say a lot of times, sometimes there's a mismatch between what is agreed to in a contract as far as a liability cap and what is the liability cap or the insurance coverage in your insurance policy. And so please be mindful. And this is another one of those things that happens through the growth of the business when you're dealing with contracts and the value of the contract increases because you're doing larger contracts, you're spending more time with a particular client customer, and the insurance coverage does not increase commensurately with the value of those transactions, and more specifically, the potential liability of those transactions that are put back onto you that you may assume are covered by your insurance, because why wouldn't they be, right? And so be mindful of that. Indemnification, we've talked about that. So indemnification is basically an insurance policy that is provided by the other party if they do something bad, and you get hit with that liability. Now that is very like 100,000 foot level of what indemnification is, but essentially that's what it is. And a lot of times you will see in M&A type transactions, indemnification, and then a holdback of purchase price proceeds that are held in escrow to basically fund that indemnification for 1 year, 18 months, 2 years, whatever the period is. Pricing protection. We talked about this a little bit in the past about what happens with price fluctuations. We talked about it most recently in the context of tariffs. What happens in those contracts that you signed that you had some stability in thinking and knowing what those prices are going to be, the cost of production. And then we even, in a prior session, I put up on the screen a component. I think it was like an Apple. It was an Apple, it was iPhone, and the components that are in there and the source of where they're at and the tariffs that would be applied to each of those components to give you a new grand total of costs associated with that phone prior to and after tariff imposition, and who is going to bear the burden of that, which would be ultimately the consumer. I think earlier on, a lot of businesses were, as far as I've seen and what has been reported, is that businesses kind of took on the burden of that, at least for a little while, but we're seeing price increases. But then again, and this is not a political statement, but the kind of changing of the mind in the White House as to whether it's going to be 50%, 30%, 20%, is it going to start next month, tomorrow, 3 months from now? So, there's still a lot of chaos going on. Dispute resolution. Should you implement a mediation, non-binding mediation process where everybody gets together in the same room and tries to negotiate and resolve it with the higher ups, because it may be the operational people that are dealing with the situation. So now get the senior person, the CEO, and it may be the person who is overseas because the parent company is overseas. Get them in the room to negotiate that, and then what happens from there? Is it binding arbitration kind of thing? One thing that we haven't talked about is IP ownership. And I don't know, Christian, if you want to discuss maybe generally what we have going on with respect to an owner who contributed allegedly IP into the relationship, which was not the case. It was essentially a license. And that's been our position for many, 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 many months. And I stress that because that's what can happen if you are not protective of your IP. Not a ding or editorial on what happened in that particular situation, because everyone thought everyone had the same understanding, and then when they were at odds with each other, then it was peeling things away and saying, well, is that exactly what was meant, and being able to obfuscate the situation when everybody was clear at the outset, I believe, what it was about.
Yeah.
So protecting IP in a business relationship, if you would touch on that.
Yeah. I mean, it's very important, obviously, without divulging any client confidence or, attorney-client privilege information. I mean, what essentially had happened was, an existing business that had registered trademarks was going to go into business with a new partner to open a new location. And in the capitalization table on the operating agreement, where one guy contributes the money, the other guy contributes the sweat equity, that's common. But they had changed that a little bit. And the guy with the IP, it just said your contribution is your trademark, your registered trademark. And it wasn't an issue until the business divorce. And then, we took the position, obviously representing the trademark owner, that of course he only contributed a license to use the trademark, to the new business venture. Why would he relinquish the ownership of the intellectual property? And of course, the other side says, no, that's exactly what you did. It doesn't say license anywhere. And, I think legally at the end of the day, we were able to convince the arbitrator that the law would make that be a license. But it just, you wouldn't want to go through that litigation and that dispute to get to that result. So you want to make it clear, intellectual property should be transferred through licensing agreements that are properly written and documented. You want to make sure you're not giving away your IP. So that's definitely an area of importance. And, licensing terms gives you more power. You can restrict the duration, the use, all the different things. So it's important for a lot of reasons.
Which is a fantastic segue to the next thing that I really hadn't intended on talking about, but we should, and we've talked about in the past, which is protecting your IP, and both operationally, but also in the context of an M&A transaction, whether you're in particularly as a seller. I would say going back into the time machine years ago, decades ago, there wasn't a whole lot of value placed on the intangible assets in the form of intellectual property, your trademark. As I was going to say something sort of political, but I won't. As the internet was created, particularly claimed by a particular person, which I will not name, but has been named before, actually, maybe last week by Gary. No, actually, it was Warren that brought it up and mentioned that. But anyway, so it's intellectual property, specifically trademarks, your identity in social media, in cyberspace, has been increasingly to this day, more value has been put on that. in valuing the company for sale transactions, and valuing the company for lending transactions, in valuing the company for equity infusions. And so there's been more purposeful thought and carefulness in protecting those IP assets. Having said that, we routinely see clients who are not mindful of that, meaning that they have been putting themselves out there under a logo, under a brand. They maybe have a particular product, but they have not done the commensurate protection on the federal level, assuming that, well, they've been doing this for 20 years. They finally got popular. Um, yeah, maybe not having gone on Shark Tank, but something has springboarded them into higher revenue, which also makes them a target for copycats and for people who want to leverage off of the goodwill that's generated by the business, and either um, divert business to them, and or in the process of doing that, do what is called tarnishing the brand. And so you want to have those protections. Um, I will tell you in M&A transactions that is looked at much more carefully. What have you done to protect your intellectual property? Oh, you had this thing sourced and you're using a company in India to produce your code, your computer code for this. Um, is it yours or is it theirs? So you talk about independent contractor relationship, and is it a work for hire and those kind of things. And so in some transactions, there's been some pretty deep investigations, due diligence, and also some representations made by a seller that says, yes, we do own this. And if someone comes out of the woodwork and says that they own it because they created it, then guess what? The indemnification provision kicks in and you're responsible for dealing with that because we did not get the asset that we paid for, kind of thing. So want to bring that up. I also have a list of clauses that quietly cost you money. We talked about auto renewal without notice. So when we're talking about termination, kind of the other flip side of that is having an evergreen that renews unless one of the parties says, hey, I'm done, and says it within 60 days, 30 days, 6 months, whatever the contract says. So they can hold you to that. Confidentiality provisions that are too broad, that they don't really protect. You're not protecting what needs to be protected. Or conversely, are overprotective. There are many times where we draft contracts that will say, this is my stuff, this is your stuff, this is the stuff that we create together. The components that are mine and yours still remain mine and yours. The components that we create together or the output is jointly owned by us. If you're not careful, it could be that what you create between the two is the other side's property. And sometimes it's meant to be that way. You hired someone to integrate their stuff into yours to create something that will ultimately be yours. And what's happening in the background is you are getting a license to their stuff. But all that should be laid out into the contract. We talked about uncapped indemnities. So you have an indemnification provision, but it doesn't have a limit on it. So it's basically an unlimited insurance policy. And then vague deliverables was also on this list that I had not put on my list, but came up that, what are the intended results of the output? But in a lot of times what gets missed is, and how do you test against that to make sure you got what you were supposed to get, or that you deliver what you're supposed to deliver. And then there's a process for testing, literally opening the box and testing to make sure the product works correctly before you accept the full delivery, before you have to pay for the full amount. So there are things that are negotiated in those kind of things. I have a whole segment about M&A pitfalls that I'm not going to get into because we need more than 4 minutes or so to do that. So I'm going to pause for a moment and encourage anyone who has questions. And it looks like maybe I missed one in the chat. Yes, Christopher, you are correct. about who invented the internet. Again, I won't share that,
Allegedly.
but allegedly was in a position of power, second highest position of power at one point. So yes, you're correct. But I will open it up for questions. But in the meantime, Christian, is there anything that you have on your mind that we need to share that is just, it's like it hits you over and over, or maybe recently that we haven't covered with respect to business owners and just general operations?
I think we did touch on it, but it's like read the boilerplate, read the terms and conditions, read the back side of the purchase order. I mean, because more often than not, people just glance through that. It's like when you go to the doctor and you have to sign the waiver form, you don't really read it. But in a business setting, I really would encourage you to read it because that's where a lot of the meat of the contract is, and it's buried in there for a reason in small font because they don't necessarily want you to read it.
And I will conclude with one related thing, which is I believe, especially lawyers, so Christian and myself and others in this office are our own worst enemy when it comes to contracts, because we do not read boilerplate. I should speak for myself. I shouldn't speak for you, Christian, but I think that part of it is for me is, okay, well, I know that when I sign something that is a waiver, like at the Whitewater Center or wherever, that, okay, I know that, yes, I'm agreeing to take my life into my own hands, but I also know that if they do something stupid, like launch me out of the boat purposefully, which actually I've seen done. And our guide told us he was going to do that to the rookie driver in front of us, guide, because he kept
Yeah.
getting his group stuck in the eddies. And he's like,
Nice.
I'm going to teach him a lesson. I'm thinking, okay, well, congratulations, innocent riders getting dumped into
Yeah.
the water.
Yeah.
So yeah, they all got launched. But I also know that we can do something about it, and that
Yeah.
we are not supposed to, but maybe perhaps the demand letter comes with our letterhead on it and they find out we're an attorney. But I would say that also applies, I think, to us personally, in that to everyone, that when it's business, we maybe take a closer look, maybe not much closer, but I think a lot of times we sign up for things and like, okay, whatever. And it's just whatever it is, and we don't read the fine print, which again, might be okay, a personal assumption of risk for you personally, but when you're thinking about, and we've talked a lot about this, as Christian knows, and people on this know, we talk about culture and about how you lead and about how you're being mindful of, the liabilities that you are entering into, and the impact that signing something without carefully scrutinizing it might put your business at risk, which then puts your employees salary at risk and things like that. So don't want to end on a guilt trip, but just understand that it's natural to do that. And so we are encouraging you to be more mindful on the business side of things, to the last 2 pages, last 3 pages, last 4 pages, which people are like, okay, I see the deal's good. It's the right percentage. It's the right this, and this. And they flip to the last page where there is a signature, which also you should be mindful to make sure that you are signing on behalf of the entity in your representative capacity. I have had to dispute, as Christian has, signatures that were just signed, but it wasn't clear whether the person was signing in there, even though the front page says LLC on it. Were they signing in their individual capacity in the form of a personal guarantee, or were they individual on behalf of the company? And so
Right.
please make sure that you are signing on behalf of the company and not in your individual capacity. And in the worst case scenario, make up your own signature page that says ABC LLC by blank. You sign it, you put your name, you put your title. I've had that done. I've encouraged that to be done by clients. I will tell you that for my father many years ago, he signed something, and the argument was he signed in his personal capacity and he was not happy about that. But what I found out is that there actually was a second page that was a personal guarantee. And even though the signature block wasn't clear that he signed in which capacity, there was a separate personal guarantee that was not included. So that won the day. But it would have been much more difficult if that was not the case. So anyway, we will close with that. Christian, thank you so much as always for your insight. And if anyone has any questions about anything and wants to chat about it offline, you know where to reach me. Christian, you can reach Christian directly if you wish. His information is on our website. It's the same format as mine, which is first initial last name at shumaker.com. This video will be posted on the BGW YouTube channel and will be posted on the Shumaker YouTube channel as per usual. I have some thoughts on what we might do in the future as far as topics, but as always, encourage all of you to let us know what's on your mind and what you might want to chat about, because I guarantee you if it's on your mind, it's on other people's minds. So we want to talk about things that you want to hear about, not necessarily things that we think you want to hear about. So have a wonderful rest of the day, rest of the week, and we will see you next week. Thank you.
Yeah. Bye.